5 seconds to go. Start. As noticed, learned counsel for the state has emphatically argued in the very first place that the appellant has been declared as an absconder in terms of section 82 CRPC and section 23 MACOCA, and hence, his case deserves no consideration. Stop. The appellant's answer to this plea of the respondent has been that he had no intention to abscond or not to face the judicial process, and that the illegal and mala fide invocation of MACOCA, impinging upon his fundamental rights, could not stand validated by the alleged absconsion. Stop. Though we cannot ignore the submissions on behalf of the state altogether in this regard, and it remains seriously questionable if the appellant deserves indulgence under Article 136 of the Constitution of India, but, in totality of the circumstances where notices had been issued to the respondents, we have considered it proper to first examine the matter on merits, and to advert to this aspect of absconsion in the last. Stop. Para. A comprehensive look at the objects and reasons for enactment of MACOCA, its overall purpose signified in its preamble, and the relevant definitions in section 2, as also the punishments provided in section 3, leave nothing to doubt that this enactment is for making special provisions for dealing with the menace of organized crime posing serious threat to the society. Stop. No doubt, the enactment makes stringent provisions with several extraordinary measures, but, the peculiar nature of the mischief sought to be tackled, that is, of organized crime, has obviously led to such extraordinary measures, particularly when the existing legal framework was found to be rather inadequate to control the menace. Stop. Para. A long deal of arguments has been advanced before us on behalf of the appellant that, looking to the drastic and serious consequences, the provisions have to be strictly confused and the authorities are bound to strictly adhere to the same. Stop. The question is as to what are the connotations of strict construction by the courts and strict adherence by the authorities in the context of an enactment like MACOCA, sign of interrogation. For determination of this question, opposite it shall be to refer to the cited decisions and the applicable legal principles. Stop. Para. The case of Lalit Somdata Nagpal Supra was one involving questions relating to the application of MACOCA in respect of the offences alleged to have been committed under sections 3 and 7 of the Essential Commodities Act, 1955. Stop. Having particular regard to the enactment of Essential Commodities Special Provisions Act 1981, which was to remain in force for 15 years only, and therein the power to impose punishment was limited up to 2 years. This court held that even when power of the court to impose punishment was limited to 2 years, the offence continued to remain punishable up to a maximum period of 7 years, so as to attract the provisions of MACOCA. Stop. Having said that, and having disapproved the views of the High Court, this court, of course, agreed with the other submissions on behalf of the respondents as regards strict interpretation of the provisions and strict observance by the authorities while observing as under. Stop.